All right, we'll call the meeting back to order. That concluded public comments. And just make sure everybody understands here, we do not allow politicking. That's not the purpose of Rochester Hills, our taxpayer dollars, for having political speeches. We've had a number of candidates over the years attempted to do that, and that's just not permitted or allowed here, and it's been consistently enforced that we just don't allow political speeches for whoever is choosing to do that here in Rochester Hills. So for some of the public comments here, let's see if we can address them that were raised regarding both the ordinances. One comment was made about second reading. Why is this second reading tonight? It was a second reading because of a majority of council wishes it to be a second reading, and that's why it's second reading. Personally, can you please let me talk? Look at that. It's always interesting. I don't know. It's always interesting people that react before they know all the facts. So, and it's again, like I stated before, please, it's my turn. I didn't interrupt any of you speaking, and I expect the same courtesy back, that I'm not interrupting your time. So please don't interrupt me when I have my opinion to share with you. It's here before second reading because that's what the majority of council members wish it to be, a second reading. That is not my choice. It was not scheduled to be on the agenda tonight. Wanted to make sure all members understood what it was, but I said that if the majority of members wish it to be on the agenda tonight, it would be on the agenda tonight, and that's what it is. In my opinion, it's wrong. We should not have it for second reading tonight. We had it introduced for first. Please, I don't need any of that. We had it on our last time we had it before us about 3 weeks ago. It was for ordinance for introduction and for first reading, and there were a number of changes made that night. There was no vote taken, and then again now it's determined that the will of the majority on council wishes it to be tonight for second reading. So that's why it is here, and again, I'm one vote out of 7 regarding that. So make sure people understand what. Please do not interrupt. You know, please, just be respectful. I'm not interrupting any of your speeches tonight, except for the one that was out of order, and I'm just respecting the same opinion to be brought back to myself or any of our council members tonight that have an opinion they wish to share with you tonight. So that is my opinion regarding second reading of the issue here tonight. Issues were raised on several of them regarding modification of some of the paragraphs. I guess I'll let the motion maker go over those changes should the motion maker or seconder wish to support that. So I'm really not going to get into that. Issue was raised about signing the leases. We've talked about this a number of times. Jordan Oil came to the city. We didn't go to Jordan Oil. They came to us. And the options presented, which we've talked about a number of times in the past, was one, sign the lease with conditions prohibiting wells in city parks, or don't sign the lease and it allows drilling in the city parks. So for us at that time, again, this is a year and a half ago, decision for myself that I made, one of 7, was to sign a lease with conditions prohibiting drilling, prohibiting fracking, getting a slightly increased residual fee should there be oil and gas discovered in Rochester Hills, or 2, don't sign it, which allows drilling in the city parks, doesn't prohibit it, puts the city's acreage into a pool where the DEQ can determine whether or not oil gas well is installed in the city. So for me, speaking for myself, that's why I chose to move forward the lease, as well as at least 400 other residents Rochester Hills have signed independent leases themselves that are all non-developmental leases. No wells can be placed on any of the leases that the 400 plus residents of Rochester Hills have signed for that. One gentleman here said, vote what we want. Again, it's a conflicting thing. We've heard, a number of different comments talking about what people want. I'm sure the majority are attempting to find the sweet spot of what the majority of the residents wish to enact for an ordinance. As far as notice goes for a meeting, I guess I'll defer to Mary Jo and Christine, but typically anytime someone speaks before City Council, we mail notification to each person that spoke on that topic at a previous council meeting, notice that it will be on a future agenda. Now, the agenda is not set until Wednesday, so the notices go out, correct me if I'm wrong, Thursday? Or Thursday morning, so I assume they would arrive in the mail Friday or Saturday. Okay. Now, likewise, Wednesday, it is live on the internet, so for those of you that pay attention to the internet or have the ability to reference the internet, you can see what's on every council agenda the Wednesday prior to tonight's meeting. You know exactly what's on the agenda, what's not in the agenda. Those are the methods that we employ right here to keep people informed of what's on, what city business is going to be conducted on those nights. Okay, with that, I'll save most of my comments to later on, and we'll take council deliberation. Is there anything, Mr. Stern, you wish, I guess before I get into this too far, you wish to opine now at this point?
Yes,
comments?
a couple of things, if I may. I'd like to talk a little bit more about the question of first reading and second reading, and just clarify that, because there's been a lot of questions or comments that this is somehow, if the council treats this and perhaps even adopts an ordinance this evening as second reading, that there is something foul or wrong about that. And I just want to clarify that that is not the case. Although it has typically been the council's practice, its practice of having ordinances on for a first reading and then having a formal resolution of acceptance for first reading before moving on to second reading. There is absolutely nothing in the law or the charter or in the council's rules of procedures that requires that. In fact, all the charter says about it when it talks about ordinance enactment is that no ordinance shall be finally passed by the council at the same meeting at which it is introduced. Okay? No ordinance was adopted for final adoption at the meeting it was introduced. It was introduced at the last meeting. The charter has been complied with. If you look at your council rules of procedure, Article 6, Section .02, ordinances, paragraph B, consideration of ordinances. Each proposed ordinance is read by title once for first reading and then for second reading and adoption at a subsequent meeting. That sentence has been complied with. That rule has been complied with. Now, there is no limitation on how many readings of an ordinance that the council can have. I mean, you can have 10 readings of an ordinance before final adoption. It is entirely within your control. The thing that you are prohibited by law, when I say by law, I mean by charter and by your rules from doing, is finally adopting an ordinance at the meeting it was introduced. That's not what we're doing. So if a majority of council decides that it wants to take action and consider the ordinance tonight for final adoption, it is my legal opinion that that is compliant with the charter and the council rules of procedure. The second thing I wanted to address was a comment that I believe it was Mr. Barker made about the oil and gas ordinance, which I think was a pretty constructive change that he was suggesting. And I'm looking at page 5, excuse me, section 138-4.425, paragraph 2, where Mr. Barker expressed some concern about, that's a sentence that has the 1,000-foot setback of a new oil and gas well from a residential dwelling, place of worship, and so on and so forth. It also contains a setback from an adjoining property line and from another well. And Mr. Barker expressed concern that that could be read or misconstrued in such a way where perhaps the smaller setback numbers could be construed to circumvent or supersede the 1,000-foot setback number. That's certainly not the intent, but what we're trying to accomplish here is clarity, and I think the suggestion he made was a good start in that regard, that by breaking that long first sentence into two separate sentences, I think we can achieve that clarity. So to be specific about it, what I'm suggesting, if you turn to that paragraph 2 and put a period after the word park in the second line, as Mr. Barker suggested, and then I would start a new sentence there by inserting the words, a new oil or gas well shall also not be located closer than 330 feet from an adjoining property line, and then continuing on with that sentence, unless the adjoining property is pooled with the well site property and unless the location is at least 660 feet from another well. So I think that was a constructive suggestion that enhances the clarity of the ordinance, and I'm recommending that change to you.
Okay. Anything else?
That's all for now. I'll certainly address specific questions or comments from council.
Okay. Mr. Anzick, anything we should add? Okay. Take council deliberation on this. First up, Mr. Kokner.
Thank you, President Hooper. Thank you, everybody, for coming out. And this has been a very long road, and a lot of people have spent a lot of time on this. And again, I want to thank the Planning Commission for going through numerous hearings, hearing the comments. I want to thank all the residents for their input. We've incorporated a lot of it, including I was going to suggest that we incorporate Mr. Barker's comment, and I think it's a good one. And I'd also like to thank Councilperson Morita, who has led the charge in helping put this together. I've said ad nauseum, my goal at the end of the day is to have us pass the strongest ordinance possible that is still legally enforceable. That's still my goal at the end of the day. And so looking at this, I think it's good. I do believe this is enforceable. I sort of put on my lawyer's hat. I tried to poke holes through it and thought of, is there anything here that someone could attack it? Is there any interpretation that can be argued is not enforceable? I found a minor one that I'd like to make a tweak to, and I've talked to Ms. Morita about this as well. It still meets our intent at the end of the day, but I think this will help tighten it up a little. Specifically, it's the pipeline ordinance. It's Article 6, Section 94-200 under definitions. And again, I apologize for the legalese here and how nuanced this is, but I really want to get this tight. First off, in the definition of city-regulated pipelines, I'd like to simply capitalize pipelines every single time that it appears within that definition of city-regulated pipelines to make sure that we're actually incorporating the defined term. Next down, under the definition of pipeline, again, I'd like to capitalize the word pipelines every time it appears. I think it's only once in that last sentence. Going back down, under section Section 94-202 are general regulations. And because we've got very distinct a pipeline ordinance and a gas and well ordinance, I want to keep those distinct. I think it'll be stronger that way. And so under that section, subsection K, I'd like it to read, a city-regulated pipeline, and again, city-regulated pipeline should be capitalized to make sure that we're referring to the defined term. A city-regulated pipeline shall not be located closer than 1,000 feet from a residential dwelling, place of worship, school, child care center, or public park. A city-regulated pipeline, again, that's capitalized, for purposes of this subsection, does not include those pipes which are part of the well and regulated by the state of Michigan. Again, making it clear that the regulations pertaining to wells is covered by our other ordinance, and this is a pipeline ordinance. Other than that, that's all I have.
Okay, Mr. Hedrick?
Thank you, President Hooper. There's really only one adjustment or change that I would suggest, and that is in the pipeline ordinance so that it's consistent with the oil and gas ordinance, and that's related to Section 94-205, Section B, rather than the pipeline operator shall, as soon as practical, consistent with the oil and gas ordinance, the pipeline operator shall immediately communicate with, and we could probably strike cities off of that, communicate with the 911 system. And could do the same thing in the oil and gas, just strike the word cities for consistency as well. Those were my suggested changes.
Okay, Mr. Wiggins?
Thank you, President Hooper. I just wanted to say, I agree there with Mr. Kokendorfer and his comments, try to provide the best ordinance, and appreciate Ms. Marita's all her hard work as well. And we were trying to get these ordinances done as quickly as possible because that's what we heard from all of you, that it was taking us a while. So we really worked hard over the last couple of weeks to move these along very quickly. The last meeting, we took a lot of feedback and comments from everyone, as well as Mr. Barker's in this meeting as well as tonight. So I do believe that it's the best that we can get in terms of everyone's comments, and I appreciate everyone's hard work.
Okay, Mr. Tisdale?
Thank you, President Hooper. The issue of the maps was brought up, and I just did want to get on the record. Mr. Rancic, do you have, is there something we can put up on the overhead here? And Ms. Howlett is correct. These are not MDEQ maps, but they were created by our GIS department applying MDEQ setbacks. And maybe, Mr. Ancic, you can help me with this, but if you look up, I think I've gone through this. Obviously, in the far western end, Oakland University is not a part of our jurisdiction, so that's not a possible drilling spot. As you move to the east at Avon and Adams, you have areas that are heavily wooded, that are wetlands, that have no access roads. If they wanted to put in an access road, they'd have to come to the city for that. That is building on a wetlands is a heightened scrutiny of the DEQ. So that is likely not a drilling spot. You move to the east of that, that's Rochester College, and it's in Oakland County. There has not been a drilling permit issued within a quarter mile of a natural river, so that is likely not a drilling spot. If you go directly north of that, that is Great Oaks Country Club. I doubt that the members would vote to have an access road brought in, even if it was approved by the city. So that is likely not a drilling spot. At the very south end, along South Boulevard, you've got Pine Trace. That's city-owned land, and we've already expressed our opinion in a lease. We're not in favor of drilling on city-owned lands. To the extreme east, Mr. Ansick, those are landfills.
That's correct.
The city, MDEQ, has never issued a drilling permit on a landfill due to the unstable nature of the ground based upon all the organic material underneath. Straight north of that, in the far corner along Mead Road, that is within the city of Rochester Hills. Well, that one is within where you were right there, stop. That's within a quarter mile of a natural river, and there has never been a permit issued in Oakland County. If you go to the east of that, I believe there's a residence across the street that would run into the 450-foot rule. It's outside of Rochester Hills, but that would still apply to the MDEQ. My point here is that as you start to cross out the existing MDEQ Part 615 setbacks, a total of 7 of them, I think there are about 8 to 10 possible drilling sites in the city of Rochester Hills, should an individual want to exercise their property rights and monetize their mineral rights. Now, if you would slide the other map over, Mr. Ansick, what he's identified on this map are the industrial zoned sites with the 1,000-foot setback, and essentially, again, on that far eastern edge, is that in that landfill area?
It is.
It is as well. So that's out. So essentially, you go from 8 to 10 possible drilling sites to 5 possible drilling sites. But they are within industrial zoned areas, and they do have the 1,000-foot setback. Those are improvements. That's an improvement upon the current situation. And so the idea that there were going to be drilling rigs springing up all over the city is just not accurate. And again, when we enhance the DEQ standards by restricting this to industrial zone sites with the 1,000-foot setback, that is entirely dependent upon the acceptance of horizontal drilling. Otherwise, we can't, under current case law, apply this type of geographically specific unit restriction. Again, you go from 8 to 10 possible drilling sites to 5. And the issue of the maps was brought up, and I just wanted to illustrate exactly, if implemented, what this proposed ordinance would implement. Thank you.
Okay, thank you. Ms. Marita?
Thank you, everybody, for coming out. I'd like to express thanks to my fellow council members. This has been a work in progress. It has required each of our council members to sit down and hear the other side of an argument. And we've all had to come together and reach a resolution as to what we thought was appropriate for the ordinance. Nobody got everything that they wanted. And I think it's a good compromise amongst council as to what we feel is legally enforceable, what will do the best to protect our residents. And, you know, whether it's a first or second reading, that was an issue that was discussed amongst some of the council members and Mr. Sarin prior to tonight. I had originally been advised that the ordinances weren't even on the agenda at all for tonight's meeting, and I requested that they be put on the agenda. And then all of the other council members had to also request that they be put on the agenda. This is important that we keep moving on this. It is not something that we can afford to sit still on. And having a pipeline ordinance in place with some protection is better than a pipeline ordinance with no protection, is better than no pipeline ordinance at all. And these ordinances needed to move forward. So there was a movement amongst council to bring these ordinances back for discussion tonight for the protection of our residents, because we didn't feel it was safe to wait any longer than we absolutely had to in order to have these ordinances come back because of what's going on in one of our neighboring communities. Now, I know we have a moratorium in effect. You know, the validity of that moratorium is something that has been disputed. And I personally feel safer, moratorium or no moratorium, with an ordinance that is in place. Is it a perfect ordinance? I don't think there is such a thing. Every ordinance on the books is subject to interpretation, and that interpretation changes over time, which is why we constantly have to amend our ordinances. I expect that after we've lived with this ordinance for a while, that we may want to come back and make some changes to it. There may be other things that we need to consider. There may be changes in technology that require revision. But in terms of what we know right now and how to best handle that right now, these ordinances, I think, fairly represent the hard work of everybody on council, the consideration of everyone on council, an immense amount of work by Mr. Starin, which should not be overlooked, who did a lot of the research, and a lot of work on behalf of staff providing us with backup information as to what is appropriate in the ordinance and what we felt was defensible. And with that, I move the acceptance of the ordinances.
Okay, with the changes, which changes are you?
With the changes suggested by Mr. Kokendorfer, Mr. Hetrick, and Mr. Starin, all of them.
Okay, is there support? Support by Hetrick. Okay, discussion on the motion?
Mr. Hooper, can I just ask for clarification, just so we so we don't have any questions or misunderstandings in the future? Is the motion for final adoption of the ordinance this evening? You used the word acceptance.
Yes.
Is the intention
yes.
final adoption?
It is. Thank you, Mr. Starin.
Okay, motion by Marita, supported by Hetrick for final acceptance and adoption, with the changes discussed verbally tonight by Kokendorfer, Hetrick, and Mr. Stern. Okay, discussion on the motion, final discussion? Okay, I guess I'll weigh in at this point. With all due respect to my professional fellow council members, I part company with them on this one. For several reasons. One, like I mentioned earlier, the second reading, while legally permissible, I think it's the wrong thing to do. I think, please, it doesn't solve anything or serve anything, any purpose at all. It's the wrong thing to do, in my opinion. Historically, for Rochester Hills, and whether we go back, however many years we go back, whenever ordinances are introduced, we have a first reading. There's changes, a fair amount of times there's changes made to the ordinance, and then there's a vote taken. And then it comes back with a second reading, and it's very rare that we make changes again at the second reading. Usually it's all hammered out the first reading, and then we vote on it. For this particular ordinance, it was introduced, and I respect Mr. Starin. It's legally permissible. Introduced. A vote was never taken. And now numerous changes were made, and now tonight we're making more changes. And we're voting on it tonight. It's wrong. In my opinion, it's wrong. 1 vote out of 7. There are a couple things in the ordinance itself, I think, that are wrong, and I disagree with. One is the monthly monitoring of the well sites. I think it's unrealistic and arbitrary. I think it'll never be enforced. I just don't think it's ever going to happen. The DEQ, I talked to the DEQ. They've supervise the installation of 60,000 wells in the state of Michigan. They have 20,000 active wells in the state of Michigan. And I asked them, what is your groundwater monitoring frequency that they do? And they're the experts that we rely on for this. And their groundwater monitoring is every 6 months. So I guess if we feel it should be a monthly, then they have it all wrong for 20,000 active wells in the state of Michigan. I think that alone makes our ordinance, pokes a major hole in our ordinance, makes it unrealistic, arbitrary, and a lawyer's going to have a field day with this. Third thing is, why move to an ordinance tonight when we got a moratorium in place? And if our moratorium's no good, what makes our ordinance that much better? Moratorium prohibits installation of any oil and gas well. So there's no rush. Let's get it right. And if it's not right, let's extend the moratorium until we get it right. So I think what we're doing right now, I think while maybe politically expedient, I think is, again, in my opinion, the wrong thing to do. I think the version that that's being, again, changed tonight is not the right version to pass. I think the Planning Commission scrutinized this in quite a detail, and the version that they recommended, I think, in my opinion, pushed the envelope far enough to where it had maybe a ghost of a chance of standing up to litigation. And I supported that version. This version, I think, is outside the mailbox. But bottom line in the whole thing here is that this is going to pass tonight without my support. I'm a realist. I understand that. You can read the tea leaves. And I think also, I really believe with Mr. Tisdale and Planning Economic Development's maps, it's very remote that a well will be installed in Rochester Hills. I think the chances are very remote. But even if one is installed in Rochester Hills, I can virtually guarantee we're going to have a lawsuit that's going to throw out this ordinance, because this is not going to stand the test of time. And I think that's what makes this, politics at its worst, that we're passing something to appease a number of individuals and makes a field day for attorneys to further scrutinize and debate this and have the taxpayers, foot the bill at the end of the day for it. So with that, we have a motion by Marita, supported by Hetrick. And let's take a roll call vote. Yes vote is in support of Mrs. Marita's motion to pass this ordinance and adopt it tonight.
President Hooper.
No.
Vice President Tisdale.
Yes?
Mr. Hetrick.
Yes.
Mr. Kokendorfer.
Yes.
Ms. Marita.